Welcome back to the Texas Appellate Law Podcast. I'm Todd Smith.
And I'm Jody Sanders.
So Jody and I are going to visit today about a topic that we've publicized a little on social media, and that is, I guess, to set the topic up, maybe we should just recount the fact that we spent a lot of time on this show talking about ways that practitioners can make the court's lives easier, make it easier for the judges to do their jobs. And that's a valid topic of discussion. And certainly that's one that our judges like to talk about. And I would too, if I were in their position. But we thought we might flip the question around and cover some topics that we've come up with and that some of our listeners have sent in about the things that the courts can do. The courts have the power to influence or change that could make the appellate practitioner's job easier or better in some way. And we've each come up with a list. I have a list of probably half a dozen pet issues or so. And Jody, I know you've got at least that many or about that many. Not that we have grievances per se with our court system. It's just things that we've identified that maybe could make our lives go a little smoother.
Yeah, this is not going to be our Festivus episode where we're airing our grievances.
That exact thought and phrase entered my brain when I first came up with this topic, because I was jokingly wanting to title it Things the Courts Can Do to Improve the Experience of Appellate Practitioners or something like that. And I guess that is sort of the general idea. But we also, like I said, we had some listener suggestions that were really good. And so we'll cover some of those too as we have time. Now, the fact that we've probably got a list of, at least 20, maybe it is a little like Festivus. I think some folks kind of decided, hey, this is my chance to air it out. Because of the size of the list, we're not going to have a lot of time to spend on any one topic. But I think there's some things in here that we can mention, make a few comments on, and then if there's any discussion to be had between us, we'll do that. And then we can always cover any one of these in more detail in a later episode. But I think our goal here was just to, for one, just identify the areas in which the court system could be potentially improved for practitioners, and I'll include clients within that group as well. And then secondly, give us an opportunity if we want to later to flesh those topics out. I'll spend some more time talking about them. So what I'm going to do is I'm going to kick us off with one of my favorite topics as far as things that could be done to make the practitioner's life better. And that is to revisit the whole concept of a civil docketing statement in civil appeals. If you practice appellate law in Texas, you know that as the appellant and sometimes as the appellee, the courts require you to file a docketing statement, which is these days a fillable PDF form available for download on all the intermediate courts of appeals websites. I always found it a little odd that you don't have to do one for a mandamus, whereas you do for an ordinary appeal. I remember the days when these statements were even less modern than they are now, that I think all the courts basically had their own version at one point.
They did.
And about 10 or 12 years ago, maybe a little bit longer, there was this effort to standardize the form, which was a step in the right direction. But it's still, that much time has gone by. And as we all know, technology has evolved significantly. And so just for context, the real purpose that I always understood of a docketing statement was just as an administrative tool to help the court make sure that it had all the information it needed about the case. So, if you go through the form that can be downloaded, it identifies all the lawyers, identifies the court reporter, the clerk, asks some basic questions about the case. If you're going to file an affidavit of indigency, if you're going to supersede the judgment, or if there was a motion or action extending the timetable for appeal and that sort of thing. And that's all fine and good, really, because I do understand that courts, I think one of the things that happens is that the clerks get these and do sort of a jurisdictional check, which ought to happen. If the court sees a problem with jurisdiction, that ought to be easily identified. But the form itself, in the age of fillable forms online and the kinds of tools that we have available software-wise, I'll just say it is horrifically outdated. To have to go in, and if it is, in fact, a fillable PDF, you've got to deal with formatting problems. And what if the text doesn't fit in the space that you're allowed? And there's a few things like that I think could be made easier. I've already mentioned it, but I think my idea on this is really this ought to be basically an online fillable form. It is administered through the Office of Court Administration. I don't know that any of the justices on any court or anybody on the Supreme Court ever actually sees it.
That I don't know.
So it seems to me that just the form if you will, of the form is something that if the courts are going to continue to require it, it ought to be updated and pretty substantially and using some of the tools that are available now in 2026 instead of in, it was the 2000s, maybe early
Yeah.
to mid 2010s when this form was updated the last time. And it seemed like a big step forward for it to be even a fillable PDF
hmm
as I remember. But
Well, and for example, you have to put in the identity of all counsel up front for both sides. Then
hmm
in the end, you have to put the identity of everyone that you serve in a separate part of the form.
hmm
Then when you're setting up, if you're the appellant, for instance, you have to put in all that information on the e-filing system to be able to serve them in a new appeal. So that's now 3 times that you're effectively putting in the same information, which seems kind of, to your point, couldn't we do it all online somewhere where you only have to do it once?
Exactly. Exactly. And we were e-filing at the time this form was updated, but I mean, the e-filing system's gotten better, I think, since then. To your point about one of my big gripes about this form, and again, it's not Festivus, but to your point about identifying the parties that you're serving, the rule was changed a couple of years ago to remove the need to even serve appellate court documents on parties. And so maybe I'm a little bold, but many times I won't list the names of the parties that I'm serving. And I'll note in the area where there's a certificate of service that the certificate of service is no longer required under the rules.
Wow, man.
That hasn't got us anywhere so far, but I have not had much blowback on that, if any, of all the times I've filled out this form. But I mean, there are some legitimate purposes it serves. You would think part of me wants to say, hey, can't they get this all from what's in the trial court's file? A lot of it, yes. And in the age of, AI, could you have a bot scrape the trial court's file for all this information? Not quite all of it, but the court reporter is that sort of thing. It won't say whether you've made arrangements, with the clerk or the court reporter. You won't know without a form or something like this, whether there's a bond that's expected to be filed or extraordinary relief that's going to be pursued. It does have also the sections for the courts that participate in this on both the ADR mediation programs of those courts and also the State Bar Appellate Section Pro Bono program. So those are worthwhile bits of information to gather, but there's nothing about this old style PDF that wouldn't allow that information to be gathered another way. So I'm just going to make a call for OCA, which I know there's somebody new at the helm as far as the technology director of OCA. I'll have to bend that person's ear, but I know in keeping with the overall theme of this episode, this is something that getting some direction from the courts themselves and not just from the administrative offices, the OCA technology folks. They don't have a dog in the hunt. It's
Right.
the people that have a dog in the hunt are the clerks at the intermediate appellate courts, primarily, and the lawyers. And so I
Mhm.
would love to see the courts, clerks, and lawyers work together to come up with another option for gathering what needs to be gathered administratively to help the court process its appeals. And so I'm just going to suggest that discussion start. Okay. So, all right. That's probably the closest to Festivus I'll get. Maybe. We'll see. What do you got, Joe?
So one of mine has to do with sealed records, and it's not necessarily a criticism of a court or practitioners. It's more of just I don't think people recognize the impact of sealing documents and what that creates on an appeal. So, the Fifth Circuit is extremely narrow in terms of what they permit to be sealed, regardless of what the district court did. And they require district courts to go through a pretty thorough analysis in federal courts. State courts aren't the same. Certainly, Rule 76 has specific procedures that you have to go through, but I think different courts, different clerks, different court reporters all handle sealed evidence and camera evidence differently. So when you're coming to actually preparing the record, that creates issues, then getting it to the Court of Appeals, then being able to access it as the party trying to access the right. There's not really any standardization, and it just makes it more difficult, I think, for everybody on each side, practitioners, courts, the people preparing the records. And so I don't know if there's a way to sort of streamline that process. And then also, this is just sort of a caution for attorneys. Certainly, there are things that need to be sealed. There's no question about that. But think carefully if you have a case that you think is going to go up on appeal about how and what you seal. Are you sealing an entire motion? Are you sealing pages? Are you sealing exhibits? Are you just going line by line? There's reasons to do each of those things. but think carefully is all I'm going to say, because it really does create headaches for every participant in the system when you start doing it.
I want to say that the SCAC, Supreme Court Advisory Committee, is looking at trying to update Rule 76A. I don't know exactly what the scope of that is. And based on our conversation with Rich Phillips, I suppose I should say the Supreme Court is looking at that and has
Hmm.
asked SCAC to study it. But that's a great point, and certainly would hope that's part of what SCAC is looking at in making any recommendations on changing 76A. You do have the issue sometimes if somebody gets a little over aggressive on what they think should be sealed. We definitely need the procedures have to do what they're supposed to do, which is to protect confidentiality.
Absolutely.
But there's a balance in there somewhere, and we don't want them to be more unwieldy than they need to be. Okay, that's a good point. I am going to resume a little bit of a gripe about some things that I've seen at the Supreme Court of Texas in recent times. I was super proud of our Supreme Court when it became a pioneer in broadcasting oral arguments live. The
Hmm.
YouTube channel, I was very proud of the court. I was proud of St. Mary's, my law school, for helping the court get that started. And for many years, that was a great partnership between St. Mary's and the Supreme Court. And that's continued, thankfully. I think it's one of the things that really does make our lives better is, I can sit here in my office and watch if there's a case I'm interested in, the oral argument in real time on my computer. And they're available 24/7. I can go back and look at other arguments. And I think that's a tremendous benefit to lawyers and the public. Just being in favor of as much transparency as is reasonable for the court, because we've talked about on the show before, for the public to have confidence in our courts, transparency is one of the biggest tools that the courts can use to help move that along. And so not too long ago, we were talking about the changes to the petition for review system. I went on a little rant about the internal operating procedures paper no longer being posted on the court's website. I still think that or an equivalent ought to be there, just for
Hmm.
kind of the same reason that you don't want to be perceived as hiding the ball, and that's not what I think is happening with the court specifically. But if you're going to have a paper like that, admittedly, it needs to be updated in light of the changes to the petition process. And as I've also acknowledged, the court did add some procedural notes on the end of the order approving the rule
Hmm.
change that I think are helpful. But boy, what a tool that IOP paper was way back in the day before January 1, or when it was still posted on the course website, because you could look at that paper and kind of figure out, all right, when should I start looking for a ruling on my petition for review? Based on the way they explain the votes and how that all fits in the court's conference schedule. You can look at the court's conference calendar online and say, okay, my petition's been there for X number of days or however long, and you could kind of make a guesstimate as to when you might really start watching the orders closely. I'm sure all those rules are largely the same, but we've heard that there's going to be faster decisions made on petitions for review now under the new rule. And so it would be really nice if there was one unified document that included all the voting information, the number of votes it took to take certain actions of the court. I think we can go and find that, but having it all in one place that's a click away is just super helpful. But that's really not what I wanted to mention today specifically. I would still call for the paper to be updated and added to the website. But what I wanted to mention today that's in keeping with the two things that I mentioned earlier is the Supreme Court's former practice of, in advance of oral argument, like the week of oral argument, sending out emails with a list of the cases being argued,
Hmm.
case summaries, who the lawyers were, and links to the docket. Yes, that's all public information that can be obtained from looking at the court's website. But that was, again, one of the things that I thought was just a tremendous tool.
Hmm.
And I relied on that email, just like the Friday orders email. Even though I know orders come out every Friday, that Friday's orders email would tell me, hey, I need to go look at these orders. This was the same. I mean, if I was tracking a specific case and already knew about it, I could get that information and know when the argument was. But if maybe there was one that got past me and I wanted to check out that case, check out the argument, or it's one that I didn't know about and wasn't tracking the issue in a specific case, but it affects one of my other cases. and it just hadn't come to my attention yet. That was a tool that I thought was just extremely helpful. I'll give Adam Schneiderman credit because I think Adam and I have had some online conversations about this, and he writes his Substack page, 14th in Colorado, I believe is what it's called. I think Adam has tried to pick up the ball on this some, but and I don't mean to say to him that he shouldn't keep doing that, but really when it came straight from the court, it was just a tremendous resource that I would really encourage the court to start doing again, just again for purposes of maintaining as much transparency as possible and really, you know, being very, in other ways, customer service oriented, for lack
Mm.
of a better term. I mean, we know as practitioners that the court's not there to serve us. I mean, the court's there to do its job, but they're just little things like that that I think really can make a difference in not only how we as practitioners perceive the court, but how the public perceives it. And, you could forward that email to your client and say, hey, this case in the Supreme Court that we're tracking, here's the update on it prepared by the court. Check out this information and let's talk about it. That was just a tremendous service that the court was providing. And I would sure like to see it come back.
So my next one also has to do with records, and it's that every court clerk and court reporter kind of has their own schedule of fees that they charge for clerk's records, reporters' records, and that's sometimes across counties. And there just is no standardized cost. And I recognize that's a big ask and probably requires a legislative fix. But from an access to justice perspective and just an ability to estimate perspective to try and help clients, it would be good to have some kind of standardized cost structure. I mean, I recognize obviously the size of the record is going to impact the cost, but when you don't even know what the per page charge or the preparation of the reporter's record charges are going to be, I don't know. It would just be nice if there was some way to kind of come up with that standardized formula to be able to predict going forward what it would be.
Yeah, I remember the days of, the clerk would give you an estimate of what the clerk's record was going to cost and before e-filing. Those numbers were really big, seemingly because somebody actually had to physically go and copy the page.
Yep.
And create a paper stack that was actually filed in the Court of
Mm.
Appeals and bound together with a
The
candle
ribbon
wax
and gold
seal.
stickers,
And
which,
yeah,
couldn't be cheap, obviously.
no, it wasn't. But it made it difficult to get a copy unless you wanted to pay for a full-fledged copy.
It did. You had to go check it out and bring it back.
That's right. And don't break the seal, by the way.
That's also
Which
right. You can't take it apart to copy it.
So those days are over and have been. And I've been
Gratefully.
pleased that I think the cost of getting clerk's records in my cases I've found have never been, at least in recent times, have not been quite as shocking as they were in the beginning of e-filing, which was they were just as expensive as they were when they were getting paper files.
I agree with that.
The court reporter stuff, it depends on the case, but you know, I've seen court reporters' records that I won't say that they rivaled the attorney's fees in an appeal, but sometimes they were in the same universe for appellate attorney's fees. And so trying to get that across to a client that just getting the record is going to cost, sometimes tens of thousands of dollars is difficult. And yeah, I'm with you. I mean, some kind of standardization would be nice. I also am aware that court reporters specifically have a very strong lobby in our state. It's difficult if it were going to be some kind of broad change on this, it would be difficult to achieve. But that's another one of those industries where professions where, just like law, generative AI, you would think would pressure the cost downward
Mhm.
on that. Hope nobody wants to egg my truck after I say that out loud on the podcast, but it's just,
That's Todd
again,
Smith. He's in Austin, Texas.
it again is there are a lot of factors that go into appeals being so expensive.
No question.
And that's one, and that's generally the first one that an appellant sees in a case. It's good to flag it, good to raise it for further discussion. Not
That's right.
something you or I could solve
Nope.
here today. It's out of our hands, but just something to be mindful of. All right. So another one I came up with is this is, I suppose, relatively minor, but our Supreme Court has been so active in changing rules lately. I just want to throw this out for discussion. And that is that we don't have a cross appeal rule in our state, in the state rules. And I first came across this issue probably 15 years ago. And I had a case where there was going to be a cross appeal. And I was like, why do I have to file 3 briefs? I've got to file as the appellant, I've got to file my appellant's brief and reply brief. And as the appellee, I've got to file the appellee's brief. Can't I do just two and combine those together. And we don't have a rule that specifically allows that. Now,
Hmm.
there are, like
Yep.
I happen to know that El Paso has one. Doing more work in El Paso these days and happen to be working on a cross appeal. And it reminded me, yeah, would it be good if our rules of appellate procedure just made this uniform? And there are actually more than one intermediate court that has a local rule on this. And typically what they do is they factor in the word count from all the briefs that would otherwise have to be filed because you're basically handling two parallel
Hmm.
concurrent appeals. And so you got to meet all these deadlines, and it's like having two separate appeals, literally.
It is.
But what the local rules tend to do, and I was able to handle this by motion, and this was not my original idea, so I can't take credit for it. Uh, but I was able to essentially adopt the structure that the cross appeal rules that exist in our Court of Appeals local rules to where essentially the appellee's brief would be a combined appellee's cross appellate's brief. And then everybody gets one reply. And so you would take the overall number of briefs filed in a cross appeal case down from 6 to 4. And, you might have the same substantive arguments either way, but just the act of having to prepare the other document and brief it separately on a separate
Hmm.
timetable is inevitably going to cost the client more money.
Oh, no question.
So I thought, well, this is a good time to throw
Yeah.
this out there that, I would love for the Supreme Court to ask SCAC. I think this has happened. Maybe I need to go back and look at the SCAC archive, but to at least revisit the idea that, hey, we're trying to clean some things up in our rules. Let's make it uniform about cross appeals. And I think the court could essentially look to those cross appeal local rules as the model and
Hmm.
adopt something that would make a whole lot of sense and
Yeah.
make it really easy for the parties. Because if you don't have a local rule, then you are put in a position of having to try and agree with opposing counsel on a motion
Right.
to adjust the briefing deadline and the content of briefs to accommodate this. I've had success with courts that didn't have local rules granting those motions, and so it works out. But maybe even if we could just remove that step and just make it again, we're sort of talking about in this episode, making things uniform across the practice in Texas, that would be good.
Yeah. I like that. So
Okay, what do you got?
this is another one that, again, is not necessarily a specific court issue. I think probably requires a legislative fix, but Texas should consider allowing the recovery of supersedious bond premiums as a court cost. In the federal system, that is a possibility. In Texas, it isn't. And I think it could really eliminate or minimize a lot of the satellite litigation that goes over securing a judgment. I mean, understandably, you get a big judgment against someone, you have some leverage over them for settlement purposes if they're going to have to pay for the costs of a bond or they're going to have to fight about net worth. And I completely understand that. But the flip side of that is if you go and you get the judgment reversed or the judgment reversed and rendered or whatever it is 2 years down the road, it is not outside the realm of possibility that your client has paid tens or even hundreds of thousands of dollars in supersedious bond premiums to secure a judgment that never should have been entered in the first place. And there's no remedy for that. They're just out. And, you know, I don't know. I think having it as a potentially recoverable court cost solves some of that problem because it incentivizes both parties to work out those issues. Maybe there's a way to secure the judgment alternatively. Maybe there's just a security by agreement. But I think it cuts out those attorney's fees. It cuts out costs potentially. And it gives the Court of Appeals even some discretion on how to do that, I think, because they can tax costs how they want to tax costs on that kind of stuff. But I think that that's worth considering and at least leave it as something that's within the court's discretion to award as a cost. And maybe not in every case, but I think that putting that component in is one thing that's missing right now that could solve a bunch of problems or at least help streamline the process.
That's a really good point. You and I were chatting before we started recording about trying to think of the last time as the appellant that we had not asked for at least one extension of time on getting our brief in. Some of that, there's a lot of different factors that go into that, but being able to complete a brief within 30 days after the record is filed, it's hard to predict when
Hmm.
the brief's going to be due because you don't know when the court reporter is going to finish their getting the record done. You don't know when the clerk is going to get their part done. Whenever the second of those two things happens is when your clock starts running. And you could be in trial, you could be working on another big brief, you could have multiple appeals going at once, which is, for those of us that do this kind of work, it's the norm. rather
Right.
than the exception. And it does make getting all the work done, with conflicting deadlines very challenging. But because first extensions are so common, I just kind of had the idea that maybe we should just lengthen the amount of time between the time the record is filed and the time that appellant's opening brief is due. And I'd be okay if the court did that if maybe there was an overall policy kind of tightening up on extensions a bit. The different courts treat extensions differently.
They do.
A lot of courts, it's actually really easy to get that first extension. I mean, it's automatic practically, even if it's opposed, and they should never be opposed, by the way. But you start getting into that second or even third extension, people start getting a little uneasy about the amount of time it's taking to get a brief in. But you still are facing those same problems
Right.
with you've got conflicting deadlines. Something else happens. You get called into a trial. You have to help with a summary judgment motion. So I'm not saying that you eliminate subsequent extensions, but I do think that for me, I mean, I think I would look at the case a little differently if I got in a new appeal that I was a stranger to. If the court would give me 60 days to get an opening brief in with one, say, more or less automatic extension. I mean, that's 90 days. That's a long time.
It is.
And the understanding that, subsequent extensions would be more difficult to obtain, I think that's a rule I could live with. And in part
Mhm.
because it's just a little too easy, and I'm guilty of this. It's a little too easy to say, "Oh, I'll just get an extension on that deadline. I'm busy." We all ought to take the court's deadlines seriously, but it is just exceedingly difficult if you are brand new to a case and you don't know exactly when your deadline's going to start,
Mhm.
the clock's going to start on you, to adjust everything to where you can drop what you're doing, handle an appeal from, say, a 2-week jury trial and
Yep.
get a brief in 30 days. And
Absolutely.
unless the court really wants to collect that $10 filing fee for those first motions, it might be easier, more efficient for the court and the clerk's offices to maybe not have so many first extensions. So,
Well, or, as you're talking, you've got me thinking maybe there's even a process that's sort of similar to what we do in trial courts with discovery. You've got a level one, a level two, or a level three case in terms of
mhm,
scheduling the briefing. And maybe it makes sense that, okay, this is a level one case. This is a one issue summary judgment appeal from a discrete record. It's due within 30 days, 45 days. This is a level two.
mhm,
It's a little bit more complicated. So it's going to be the initial 60-day deadline. Level three is, oh, this is a cross appeal. Hey, we've got multiple briefs. We really just need
mhm,
to enter into
mhm,
an agreed briefing schedule. Let's do that. I don't know. Maybe there's a process to have something like that at the outset, which kind of goes with what Justice Gunn was talking about a few weeks ago. Maybe
mhm.
that's the status conference. Maybe that's when you have a status conference with the court. The record gets filed. You get a status conference set within a couple of weeks or a month. All the parties come in, you talk to the court about here's what this is about, here's what the record is, here's what we think some of the general buckets of issues are going to be, here's what we think we need to do to be able to brief it and get it submitted. I don't know. Maybe that's how that all fits together.
Yeah, I like that. And now that was an intriguing idea that Justice Gunn threw out. And I think, as I said when he did, I was like, this is something that ought to be studied. And it also makes me think, your comment just now also made me think of the Fifth Circuit mediation program.
Hmm.
When your clock's not even ticking yet, the court has screened the case, ideally with very useful information gathered through a new docketing statement that's fillable online. Imagine.
Hmm.
And now, do they create a mediation staff attorney like the Fifth Circuit has? Have the whole office, I think. Maybe, but if you really want to facilitate resolution of cases on appeal, I mean, I think there are plenty of cases that settle through that program. And so rather, even before the parties even commit the time and expense it takes to brief a case, they know what the issues are usually
Hmm.
in a case. And they know more or less what the risks are, at least as they exist coming out of the trial court. Now, the appellate lawyer should be adding value to that
Absolutely.
and either increasing or decreasing the risk of there being a different outcome on appeal. But I do think that overall thing, the overall scheme that we just went through has appeal to it, no pun intended.
No, we need to intend that pun. Sorry.
Nah, yeah, we can't help ourselves. But no, seriously, think about it. I mean,
Yeah.
you get better information up front through the through the docketing statement. Parties can agree maybe on whether it's a level one, two, or three
Hmm.
equivalent, and maybe that does change the initial briefing deadline, and you get potentially the input of a staff attorney. And the trick would be, do they handle this court by court, or how does that work? Because your
Right.
3-judge courts are going to have fewer resources
Sure.
than, say, the Dallas or the Houston courts of appeals. But it's something I think worth exploring, because I mean, we just spend a lot of time thinking about extensions and how to manage our workload. And
We
this
do.
would be something that would be, I think would be a big benefit overall if it could all be pieced together into a way that really takes into account the case itself and not just treats all cases the same, all non-accelerated appeals, I suppose.
Right. Well, and maybe there's a whole different set of rules for accelerated appeals, and that makes sense. I don't know. Just
No.
there's a solution in there that somebody probably smarter than us can figure out, but there is room for improvement across the board on that, because all appeals aren't created equally, but right now our rules kind of treat them as if they are.
Yeah. Good point. I like it.
Okay, I think it's back to me. Let me look and see. So, this is an issue that is difficult, but a lot of times in cases, sometimes in the trial court, sometimes at the appellate briefing, sometimes in both places, there's bad behavior by counsel that just sort of gets, I don't think it's unnoticed, but it gets unaddressed. And I'm not saying sanctionable, but I wish courts were a little bit more open to call out some of that bad behavior in their opinions, because when it goes on and you get your Court of Appeals opinion and it doesn't really mention any of that, I understand it, but it is helpful sometimes when you get the opinion that takes just a minute to kind of say, look, this was in the brief, this shouldn't have happened, or this happened here, this shouldn't have happened, because it discourages it. And I think, broad generalization, sometimes it comes up when you have trial lawyers playing in the appellate courts, doing the appellate role, maybe not understanding the standards of appellate conduct. It just, you get different tone, you get different ways of handling things that maybe don't fit. And I wish courts were a little bit more open to gently admonishing that, just so that it would serve as an example, I think.
Yeah, I agree. I've seen it happen the other way though too. I've seen unwarranted criticism
Yeah. And I think
in some
that's the
opinions.
difficulty, is where do you draw the line? But I don't know.
Yeah. There are times that I wonder if, when I'm reading appellate opinions, when the last time was that the authoring justice represented a real client in a real case. And so that has to be factored into, because, I think what tends to happen is you get into the ivory tower of being an appellate justice, and you have your one job. And it's easy. You kind of get detached, I think, from being down here in the ditch with the rest of us, trying to represent clients and do the best by the clients. But I'm totally with you on, there's conduct that just shouldn't be happening. And yes, trial judges, you do it too. not not I wouldn't say that's a frequent occurrence, but if the court is just refusing to follow a rule, for example,
Hmm.
I think that's okay to call it out, because the client, from our side of things, the client is entitled to rely on the court applying the law faithfully. So that's perfectly fine. And then when a lawyer is doing things that are just outright improper,
Right.
I've got an appeal going right now where my trial counsel is after me essentially to try to get the trial lawyer from trying to, or from doing something, in this case, supplementing the record with things that weren't before the trial judge, and thinking that there has to be a remedy for that. And of course, I don't want to give any more detail than that, but you know, if there was a remedy for it, besides, say, moving to strike the improper
Mm.
supplement, if the court would say something other than just a generic, we're not going to consider that on appeal, and that's
Hmm.
fine. But, you know, I think a bit of a bench slap occasionally is not a bad thing
Well,
if
and
somebody's acting out of bounds.
well, that's right. And I think about kind of the series of AI cases that have made their way across social media about parties with hallucinated cases and briefs and stuff. I think courts have done a good job of kind of explaining how those cases come about, what happens. I think they've done a good, and I just wish that
Mhm.
happened more in some more standard kind of civil appeals and trial court things in state court, because I just don't think that that gets done enough. And I'm not necessarily talking about AI. And I'm also not talking about just someone has a bad day and makes an off the cuff remark that they shouldn't have, or a judge yells at parties when they're frustrated. It's more, there's conduct that clearly goes over the line of acceptable standards that just kind of gets ignored.
Yeah, and this kind of dovetails with the idea that appellate courts just really don't like sanctions. And so this gives the court, I think, an option to do something, in air quotes, without resorting to sanctions. And although I tend to think that appellate sanctions are underutilized because I think there are times when there's just nothing short of a sanction that will deal with a certain behavior. It's the bad stuff. It's not
Right.
just, you didn't cite a case in your brief or something like that. It's things that just where there really isn't any question that
Right.
certain conduct ought to draw sanctions. And I'd like to see the courts exercise their authority to sanction lawyers in appropriate cases. Should it still be rare? Yes.
Absolutely.
But if it never happens, then where's the deterrent?
Right.
So kind of to that point of deterrence. But yeah. Okay. Well, I've got one or two more. And we still have a few on the listener suggestion list aside from what you have. But
All right.
one of the things that I've noticed really, I guess, over the last year more than anything is that, it used to be really easy to go and subscribe to the regular orders lists
Hmm.
from intermediate courts of appeals. This is one thing that the Supreme Court, I've already hinted at this, is really great about. You can get on the email subscription list. I think, Osa McCarthy way back when started it.
He
And
did.
then when he left, they turned it over or turned it into a constant contact list, I believe, that you can literally opt into that simply. And so that I think is really one of the things I think the court really does right is making it easy. If you want to get a weekly email with all the orders and opinions, you just opt in like you do anything else online. You sign up. There was through the courts of appeals official websites at one point a way to do that for orders and opinions on a court by court basis.
Hmm.
And as far as I can tell, that's been broken for a couple of years. I hope somebody will tell me I'm wrong and I'm just not doing it right. But I remember the last time I looked at this issue thinking I really want to get subscribed to, say, the Third Court of Appeals. I won't give the 15th Court as an example because I don't think I tried that. But
I get theirs actually.
you get the 15th? Yeah. And that's good. I need to subscribe to that list. But, if you're practicing in, say, Eastland and you want to know what the Eastland court's doing week in and week out, you would think it used to be that you could get
Hmm.
that court's orders and opinions as they came out in real time in an email rather than, I mean, I guess you could make the argument, well, if you really care about it that much, just go look at the court's website. Yes, you can get them that way, but I'm sorry, it requires me to click a few times and this ought
Yep.
to be something either I could set an AI agent on my browser to go and get them for me. Yeah, I could probably do that.
Hmm.
But again, in the interest of transparency, make it easy for people to know what the court's doing.
Yeah.
This might be, I haven't asked anybody at OCA about this recently. It might be something for me to take up with the new technology director at OCA. So I will make a point to do that. But if there's anyone listening who has input on this, or who has a different take on it, let me know because do I want to get every order from every court? No, I don't. That would be pretty overwhelming. Select courts, Jody says the 15th is working, but the third or the Houston courts or the other courts that I'm in, more and more often, that was an extremely convenient
Yeah.
thing that when those just arrived in my inbox, and I would sure like to see those come back. The business court, as we know, is making its opinions available online. But as far as I know, those are not available through an email subscription either. And so I'll add the business court to the list of courts that we'd like to
Hmm.
see because essentially that court is treated as if it was an appellate court
Yeah.
just by virtue of it's writing opinions. There's lots of things that are made available publicly.
Hmm.
That would be one that I think would be significant to include in that list as well.
And they do a good job on their website of putting up each case that comes out. They have a public domain citation format and a
Hmm.
summary. And I think that's really helpful. And I know they have different resources than some other courts do, but it's very
True,
user friendly, which I appreciate.
true. Yeah, that's been my experience too. That's a court. Things are really starting to heat up in that court right now.
Yep.
I'm starting to try cases. And so it's just going to continue. If we could get notified of the orders and opinions that come out from that court too, that would be tremendous for those of us that are in that court from time to time.
All right. Well, I'm going to lump together a couple of them. One of them is one of mine, and another one is from our listener. This that I also had on my list, and it's the idea of kind of issue grants and telling us the issues. So one of them for the Supreme Court of Texas, I wish that sometimes they would take cases up only on specific issues. I know, and I've talked to the justices why they don't necessarily want to do that right now because they feel like they need the full briefing to be able to know what some of the issues are. I just wonder if, as the process changes and we've got this new petition for review, no more unbriefed issues, if they're going to start doing that, I think it would be helpful because a lot of times, especially if maybe both parties are cross petitioning, there's a lot of briefing that has to be done for stuff that the court's not really interested in. So that's kind of thought one. The other one is more generally for appellate courts. I wish that they would, and not in every case maybe, but in some cases at least, kind of send out in advance of oral argument, here's the topics we'd really like you to discuss. Because in a standard civil appeal that's got 3 or 4 issues and a 2-week jury trial, and I mean, there's a lot of things to prepare for oral argument. And obviously, I want to be able to prepare and talk about whatever. But if there's 2 or 3 things that the court really wants to know about, I would love to know that so that I can tailor my time to talk about what they want to talk about. I think it's just at everyone's benefit to the extent that that's possible. And, one thing I wanted to bring up that I think is interesting, the first court of appeals I noticed has started doing a pilot program. And so not exactly what we're talking about, but in some of their most recent oral argument notices, they have a paragraph in there about a pilot program that says each side is going to be allowed to open with 2 minutes of uninterrupted time. Counsel may use the full 2 minutes or only part of it or none of it. The purpose is to allow counsel a chance to prepare an elevator pitch that highlights whatever points counsel deems worthy of attention, and rebuttal will not have any guarantee of uninterrupted time. I don't know of any Texas appellate court that's done that. I think the Fifth Circuit does that with en banc arguments, just given the number of justices or judges that are going to be asking questions. But I kind of like that, knowing that you've got a 2-minute introduction to kind of orient the court and get them on what you think they need to be talking about. So I think that paired with oral argument kind of topics, boy, that'd be great for everybody because we could just get in 20 minutes have the conversation that the court wants to have, which we're going to end up doing anyway. But if everybody knows what that is and is really prepared, you can get into some great oral arguments.
Yeah, I like that. The court wouldn't be telling the advocates, these are the only things we're going to talk about.
Sure.
So to the point about issue grants, maybe issue grants are harder to do now that the rules have changed and the Supreme Court is granting without full briefs. But it's sort of almost like a compromise on issue grants. If the court will, when it's granting and when it's setting the cases for oral argument, letting you know the principal issues or issues that counsel should be prepared to argue on. I think that enhances the oral argument. You hear the story so often that, oral argument's not really necessary in most cases. That may be true, but there's always some issue that could stand to be a little more fleshed out. And in a 2-week jury trial case, to have the lawyers know up front what are the 1 or 2 things that the court is primarily interested in, not exclusively, but primarily. Sure. I think that would really help make oral argument better. Agreed. And the idea of the soliloquy is interesting too. I'm not sure I'd know what to do for 2 minutes at the lectern.
We don't have to have all of it, but I do kind of like that.
Yeah.
It's that kind of strange line between, I definitely don't want to have an oral argument where I'm the only one that's going to talk to the panel for 20 minutes. That's no fun because that's just a speech. But It's also hard when you are 10 seconds in, you said your name and the questions just start coming too. I don't know. It's kind of nice to know, okay, I can do this. I can kind of stick my 1-minute introduction in there of here's the things I want to cover and talk about and give them a broad overview. And then let's go where the court wants to go. I think that's interesting. I'll be curious to see how that works in Houston and whether some other courts start to follow that approach.
Yeah, for sure. You said that was in the 14th?
First.
Oh, in the first. Okay. I just filed a brief on the 14th requesting oral argument. So I guess that won't impact me yet, but I've got more coming in the first. So we'll see. Well, I've got a couple of, I think, quick ones from the listener suggestions that again tie into the theme of transparency. One, there was suggested that maybe the courts of appeals could put out case summaries like what the Supreme Court does. I like that idea, of course, and maybe you tie it to the orders list that we were just talking about. Again, I think the issue there is, okay, with what resource are the courts going to perform this? Do you want to rely on AI to draft your summaries and check them? No comment, I guess, but
maybe as the starting point, but I think you got to have somebody read it if the court's going to put it out.
Yeah. I mean, what the Supreme Court does is those oral arguments, or those case summaries rather, are the starting point to the paper that the court does keep updated. And a justice presents at basically every appellate CLE, the Supreme Court update. So you do this little bit of work in these summaries and it applies and is plugged into this bigger body of work that I think is very beneficial. You could read that paper, you know exactly what's happened in the Supreme
That's
Court
right.
for that particular term. Um, I think the local appellate bars might help facilitate something like the case summary idea. I don't know if there's the kind of demand for that in those intermediate courts of appeals, probably in the urban courts, but maybe not for the rural courts. But still, it would be nice if you could subscribe, get the emails of the opinions and orders, and then have a paragraph on each opinion, what it's
Hmm.
about and what the outcome was. That would be, I think, a big benefit. Kind of a semi-related point again about, I'm just going to keep beating the drum on transparency. We have some intermediate courts of appeals, including the 15th that comes to mind right away, that also make their oral arguments available
Hmm.
through YouTube. I think there may be more that do that. Somebody suggested, well, it'd be nice to have consistency in having oral arguments available online across the intermediate courts. I think you again run into resource problems with
Yeah.
that. Like there's not going to be cameras in every courtroom. It would seem you could make audio available, very
Hmm.
reasonable cost, if any cost. So that might be the best you can do in some courts, at least for the time being. But I think it's worth mentioning that
Yeah.
it would be nice if you had a case in, I'll just pick on Eastland a little bit more. If you had a case in Eastland that's, on point with yours, to be able to go and view the oral argument in that case and track it would be big
Hmm.
and help you do a better job for your clients. I think we got a few more on the list. We might be able to squeeze them all in, Jody, if you want to tackle another topic.
Sure. Well, I'll tack on to the transparency one. Someone suggested that courts of appeals start doing like a Domino's pizza tracker on their website, which I mean, I don't know how feasible it is, but I kind of love that. But I do. I mean, it's a great suggestion just because it's fun. But I think that is something that attorneys and in particular clients struggle with, and I don't know what the solution is. But I know
Hmm.
talking to court of appeals justices, they've got criminal cases that take priority. They've got parental termination cases that take priority. They've got all sorts of accelerated interlocutory appeals that take priority. And from an outside perspective, we don't really know where we fall in the mix. And I think that that's hard because when you tell the client has oral argument and they say, okay, when do we expect an opinion? And the answer is, well, it could be a couple of weeks, could be a few months. And we just don't know. I mean, that is a hard answer to give. And I don't know if there's a way to have more transparency or what that looks like. But I guess
Yeah.
all I can say is I wish there were.
Yeah, that was a I think we had more than one person in response to the LinkedIn post make that basic suggestion. A few with, I wouldn't say colorful language, but maybe descriptive language of, dealing with the black box that is the Court of Appeals, I think
Hmm.
is how that was described. And we don't want to single out the courts of appeals. The Supreme
No,
Court can kind of be that way too.
very much so.
Although it's less so since they've been cranking out opinions in all their granted cases every
That's true.
year for a number of years in a row now. But yeah, that it is really hard to advise a client when the best you can do is say, well, we just really have no way to know how long it's going to take. My concern with that has always been, undermining, well, no one's doing it intentionally, but the indirect effect of that lack of transparency is to undermine the client's confidence in the appellate lawyer
Right.
because you're supposed to know. And we have sources we can turn to. We can look at stats
Sure.
from
There's
OCA. We can
general
look at,
data.
yeah, we can look at papers that people write. And as far as how long things generally take, you know, it's kind of like saying that, hey, we have a 10% chance of getting our petition for review granted in the Supreme Court. Well, yes, that's statistically true. Is it true in your case?
Right. Right.
It doesn't really add much. That number doesn't mean much. And so those stats to me don't mean a lot. I don't know what the solution is, but if somebody could figure out a way to install the
Hmm.
Domino's pizza tracker,
That'd be great.
I,
Just Justice
I
so
love
and so
that.
has started preparing your opinion.
That's right.
Staff
And
attorney is checking it, checking citations.
I'll give credit where credit is due on that. That was Ryan Owen who came up with that.
Okay. That's
So
funny.
Ryan, if you're listening, thanks for the visual that I
Yeah.
will never forget because that would be really great if it could happen. So there's one or two more. Let me tackle one that I think will resonate with people. And that I think this was Rachel Stinson. I'll call Rachel out. She won't mind. She commented about it publicly online, but the very infamous one sentence mandamus denial. And I think my comment on this is, well, for those who don't appreciate it, most mandamuses are resolved with the following language, if not exact, very, very close to this in an order. The petition for writ of mandamus is denied. And that is it. That's all we hear. The problem with that, Mandamus is an extraordinary writ. It's not supposed to be granted frequently. The courts are not required to give their reasons for denying mandamus, unlike, as we have discussed recently, permissive appeals. But a mandamus is kind of like a permissive appeal
It is.
in that, and most often it involves as much work as an ordinary appeal or a permissive appeal.
Or perhaps even more.
Yeah, it can be more because you have to compile a record, among other things. And it's a difficult standard to meet. So it does require a lot of good lawyering too. This is another one that falls into the what am I supposed to tell my client bucket, because you tell the client, hey, yeah, you got a good mandamus. You're advising them. Yeah, I think the trial court got it wrong here. And yeah, I think this is an abuse of discretion, and I think we have a decent shot on mandamus. I don't think you get to say it's a discovery order and you're ordered to produce. There's no remedy at law for producing, say, confidential information. Once the cat's out of the bag, it's out. So when you get that particular type of order in response to the hard work that went into preparing a petition, it's kind of a gut punch.
It is.
And I have seen some courts write full paragraphs, but those full paragraphs basically just recite the standard. Well, let me say, when they do this, it is not much better than the one sentence order. And that is when they simply recite the standard and conclude that it wasn't met. It would be most helpful. I'm not sure what the court's incentive is to do this. The intermediate court's incentive would be to do this, but it would be most helpful if the court could give the parties a more specific idea of what it found to be persuasive or not persuasive about the petition, so that the client would know, so that the lawyer would know, and maybe, that would influence how the lawyer counsels clients in the future, and influence other lawyers thinking about bringing mandamus petitions in that court.
That's right.
We're supposed to do our job representing our clients, and I think it would help us do a better job if we knew what the court was thinking, rather than
That's right.
just, as I think I'll call Rachel out again on this. I think her comment was, give us more than that pro forma sentence. Was it untimely? Was there an adequate remedy on appeal? The trial judge got the law right after all. That's a good point. Or the one I was going to mention specifically is what Rachel said here. Was it raining on a Tuesday? Or, you can think of any other equivalent ridiculous explanations, but that's we can't tell anything other than that. It was raining on a Tuesday, and so the court denied the petition. So I've gone on probably longer than I needed to about that, but I think that's something that the courts could help practitioners with for sure.
Definitely.
You see any others here that you want to cover? We only have a couple left.
We've got a pretty good list. I think we've covered a lot of these.
Yeah, I'll just throw out another one. Somebody said the intermediate courts could rule fast on unopposed motions like Scotex. I'll praise the Supreme Court for that. The Supreme Court does rule fast on unopposed motions, usually in a day.
And some other courts do too. There's some courts that I get really quick rulings on things like that.
I've seen some take longer, and it's kind of a mystery as to why, but I thought that was worth mentioning.
Yeah, agreed.
Again, tying into the Domino's Pizza Tracker and transparency overall, there were folks that were complaining about delays in ruling on motions. I think that is going to depend on the motion.
It does.
If it's a motion to dismiss, of course, it's not going to get ruled on in a week.
Right.
If it's a contested motion to dismiss, if it's a motion for extension of time, that's a different story. So I don't think you can generalize much there. But if you can't tell, I think, at least from my perspective, the theme of today is for as much transparency as the courts can adopt and display, the more the better, from the perspective of the litigant's confidence in the courts, from the perspective of the lawyer's confidence in the courts, and as we've said repeatedly, from the perspective of the lawyer who is advising clients on what to expect from an appeal. That last statement kind of starts to sound a little soapboxy, so that's not really what I intend, but this is just a gentle reminder to those who have not been in practice for a while that these are the realities that we deal with day in and day out in our situation as practitioners. Jody, if you don't have anything to add, I'll just say we appreciate the judges who are listening to this. Thank you.
Yes.
Please take it in the manner in which it was intended.
Yes.
We don't really
Todd
think
Smith, Austin, Texas, state bar number.
we're not really intending to call you out, but just, I think it is important that these kinds of issues be aired. And if there's any of these that need further airing, if we come up with more thoughts on them, then we might follow up on it in a different episode.
Well, and if anybody, if any judges, rules committee people, anybody ever wants to come on and talk about these, please let us know. We would love to have other perspectives on it. These are just kind of ours from, our own experiences or conversations with other people. So if anyone has thoughts or wants to come talk about them, let us know.
Yeah, I would love that. I thought it was very valuable to have Rich Phillips come on and talk about SCAC and the internal processes it goes through and the transparency. There's that word again, that SCAC operates under. And so please, if there's a justice on any intermediate court or the Supreme Court that wants to come on and challenge us on some of this stuff, we'd welcome the opportunity.
Or just talk about it. I mean, you don't even have to
Yeah.
challenge us. If you just have thoughts that are different than ours, come on. We'd love to have a conversation.
Maybe we can get Justice Busby to come talk about why the court doesn't want to do issue grants.
Todd Smith, Austin, Texas.
I only say that because I know that he's talked about that a little bit in the past. So, all right. Well, Jody, I think this is very helpful, good conversation. I'm enjoying our one-on-one episodes
Me
that we've
too.
been doing lately. So let's keep them up. Thanks everybody for listening.